Divorce can happen relatively quickly or very slowly. In Florida, what I would call next day Amazon delivery is finishing a divorce in 90 days. To make that happen, both parties must cooperate in exchanging financials and scheduling mediation quickly. The number one cause of cases slowing down is when a party, be the husband or the wife, refuses to turn over their financial documents. The reality is they have no choice. Florida has Rule 12.285. You don't need to know what that is, but it's mandatory disclosure. Mandatory disclosure is mandatory. If you or your husband or wife refuse to turn over your financial documents, and I get it, you don't want your spouse to see that you went to the bar. You don't want to see your spouse to see that you swiped your card at the Hard Rock. But unfortunately, you have no choice. If you refuse to provide your financial documents, the other side's going to file a motion to compel. You're going to have to wait 3 months to get any hearing time with the judge. It's going to get granted. You're going to have to pay attorney's fees. Avoid the headaches, speed up your divorce, provide your documents, and so long as the other side cooperates, it's possible to be divorced within 90 days. A lot of people wonder what is the difference between a contested and uncontested divorce. But in reality, they're very much the same process. In an uncontested divorce, a client will come to us with the bullet points of an agreement. We will convert that agreement into a typically 10 to 15 page settlement agreement, plus another 8 to 10 page parenting plan that in essence, turns our client's bullet points to a fully enforceable and clear to understand agreement. In those cases, parties are allowed to waive financial disclosure unless there's children for child support. If there's going to be child support, the parties must complete a financial affidavit so that child support can be accurately calculated. If the parties cooperate, an uncontested divorce can be completed in as little as 90 to 120 days. But again, it requires cooperation. So I strongly recommend anyone seeking an uncontested divorce to cooperate with each other and, quite frankly, just be nice to each other. It didn't work out. It's going to be okay. Work together to part ways amicably and quickly. A lot of people ask, how long does a contested divorce take? A contested divorce, which is the most common type of divorce, is when there is no agreement. One party will hire an attorney to file a petition for dissolution of marriage. It takes about a week to get all that paperwork together. It's a lot, about 45 pages. Once the case is filed, the clerk of the court will need about 2 to 3 business days to issue a summons. So for example, if you file Thursday, you should not expect the summons, case number, etc. until the following Monday or Tuesday. Once the summons is signed by the clerk, a case number is assigned, and a judge is assigned, that paperwork will then go to a process server. This is part of what I call phase 1, the pleadings phase. The process server will locate the spouse and serve them personally. You cannot do this yourself. You cannot do it via email, and you cannot do it via mail. It must be handed to the other side. Once served, the other side has 20 calendar days to file an answer, and if they choose to do so, a counter petition. Once that's filed, then you have 20 calendar days to file an answer to that counter petition. As you can see, we're still in phase 1, the pleadings phase, and we're already 2 months in. The next phase is phase 2, discovery, which is exchanging financial documents. Our clients get provided a list, and the list can be found online as well, of all the documents that you have to provide with the other side. And again, it is mandatory disclosure. It's important to timely provide those documents, as again, they are not optional. Once those documents are provided, mandatory disclosure is complete, discovery is complete, and we move to phase 3, which is the mediation/litigation phase. All cases in the Tampa Bay area must go to mediation before the judge will hear any issue. And I mean any issue. Your spouse won't let you see your kid? Must mediate first. Your other spouse cut you off financially? You must mediate first. In mediation, it is you and your attorney, the other side with their attorney, in 2 separate rooms or virtual rooms with the mediator going back and forth trying to work out a deal. They're not acting as an email server. They are actually pushing both sides to get a deal. From the mediator's perspective, any deal is a good deal. That's their job, to get the deal. If mediation is successful, you can set a final hearing and move forward. You're typically looking at about $7,000 to $10,000 in legal fees per side and 4 to 6 months for the total case. And again, this is if people cooperate and move things quickly. If the mediation is unsuccessful, you'll need to schedule your case for trial. Trials typically take place about 6 to 9 months after the case is ready for trial, meaning you've already mediated and we're now setting it for trial. So as you can tell, we're looking at 12 to 18 months total. Trials are extraordinarily expensive, which is one of the main reasons people try to resolve cases at mediation. Trials can be anywhere from 15 to 40 to 50,000 per side. At Tampa Divorce, we are always ready for trial. We do everything as if we are going to trial, but also reasonable in trying to work with our clients and the other side to come up with a solution that benefits our client. I often get asked, what is a collaborative divorce and is it right for me? The name collaborative sounds nice. It sounds like we're all going to work together to come up with a solution that benefits everybody. And for the most part, that is the intent. But I always advise people to be careful when choosing a collaborative divorce. In a collaborative divorce, both sides hire attorneys. So the husband has an attorney and the wife has an attorney. They also hire a joint counselor or therapist. In addition, they hire a joint CPA, a certified public accountant. If there's a child or children, they may hire a guardian ad litem. Rather than file cases through the court, they will meet together through these meetings. They will exchange financials and do lots of work collaboratively to try to move the case forward. If the case is resolved, the collaborative agreement will be drawn up. One of the parties will go to the final hearing and the judge will sign off on it. The bad part about collaborative cases is what happens if there is no agreement. So with a typical divorce, we'll file, they'll get served, we'll exchange financials, we'll go to mediation, and if mediation is unsuccessful, we'll set the case for trial. But in a collaborative divorce, we'll file, exchange financials through the CPA, meet with the counselors and therapists, meet with the guardian ad litem, and push the case forward. But ultimately, if the case cannot be resolved by an agreement in collaborative divorce, you have to start all over. In other words, you've put all this time, all this money, all this effort into your collaborative case, but there's no agreement. That means you start over. Not only can you not use your original attorney, you cannot use their firm. So you must start the case completely over from square one, and all the money you spent is gone forever. Both sides must get new attorneys. The documents or agreements or negotiations produced through the collaborative process are gone. You cannot use them in court. So be careful. Collaborative divorce can be great, but it can also be used as a weapon if one side wants to expend the other side's money, and then they actually go through a contested divorce, and the other side has no money to fight it. So collaborative can be great if both sides are committed to working together. And again, think of the game show where they choose share or steal. If one side chooses steal, they take everything, and the same is true with collaborative. But as long as you both are willing to share and are willing to cooperate and participate, collaborative divorce can be a great option for you and your family. People often ask, is collaborative divorce faster than a contested divorce? And the answer is not really. Collaborative divorce consists of multiple meetings and exchanges of documents, so you're looking at around 6 to 12 months. Whereas a contested divorce, you're still looking at about 6 months to get to mediation, but if that settles, then you're done at 6 months. So the main difference, though, is with collaborative, if you are unsuccessful in settling, you're starting back at month 0, and you still have to file contested, so you could delay your case by 6 months to a year. Whereas with contested, you just keep going. Okay, we didn't settle at mediation, let's set the trial date and we'll go from there. My clients are often confused by the word temporary when it comes to temporary orders that are entered in cases. A temporary order lasts until further order of the court or a subsequent agreement ratified by the court, meaning the parties agreed, the judge said sure, and rubber stamped it. A temporary order could be in place for as little as 1 day, 90 days, or years. I have a case right now where my client got sole custody on a temporary basis, meaning the other side's not even seeing the child outside of supervision. And that's been in place for 1.5 years. The reason why temporary orders are there is to protect you, your spouse, or your child while the case is pending. All temporary means is between now and a final judgment. So it could be short term and it could be final. The big key with temporary agreements or orders is that they're without prejudice, meaning that the court is not supposed to use what the elements that led to that order in any ultimate order, and they should be set aside by motion. So in other words, if you have a temporary order You are free to file a motion to modify or change that order and have a hearing before trial. So again, temporary orders are in place until further order of the court or an agreement between the parties, the husband and wife, the spouses, that is signed by the court. If you have any questions about how long a divorce takes, reach out to us at tampadivorce.com, tampadivorce.com, tampadivorce.com. We're here for you. We're here to help.